Every year, German family courts make decisions about the lives of thousands of children. Their most important basis, the psychological expert report, a document that decides if a child can see their father, if a mother is considered fit to raise a child, if a diagnosis changes a life. What happens when this document doesn't meet scientific standards? We analyzed 3 reports from the GwG, created at the District Court of Offenbach, the District Court of Wetzlar, and the Higher Regional Court of Frankfurt am Main. What we found should alarm anyone who cares about the well-being of children. The GwG, which stands for the Society for Scientific Forensic and Legal Psychology, is a private company. Its main office is in Munich, and it has branches all over Germany. Family courts ask them to do psychological reports. These reports can cost several thousand euros for each case. And they have a steady flow of work. Very steady. 40%. That's how much GwG collects from every expert's fee in their network. These aren't rumors. It's written in a letter from the Bavarian Ministry of Justice. At the Passau District Court, 75% of all family psychological expert opinions were from GwG. At the Ingolstadt Family Court, 90%. If you were a parent in these areas and got caught up in a custody case, statistically, you had little chance of not being evaluated by GwG. The Bavarian State Parliament had to deal with complaints about GwG multiple times. The then Bavarian Minister of Justice, Beate Merck, noted in a letter that complainants had accused GwG's experts of being biased, unscientific, or too expensive. That's the big picture. Now let's dive in. The business model has another side to it. The Munich Family Court held regular training sessions for family judges, together with the GwG, twice a year. The Ingolstadt Family Court ordered 11 out of 12 reports from the GwG, a leading person in the GwG network. Both of these were documented by the Bavarian Ministry of Justice. And this finding isn't just about a few people. In the reports we looked at, it was clear that experts in the GwG network held training events for family judges, documented by conference programs from the German Judicial Academy. These overlaps between training roles and later court assignments make us wonder about the separation of institutions and fairness. The training and the assignments are all part of the same system. In cases in Hesse, reports from the GwG network were made. At the same time, training activities were documented. We're not naming specific people here on purpose. What's important is the pattern. Close institutional ties and no clear lines separating things. This isn't just a one-off in the GwG system. This is how the system works. To fully understand this, Professor Volker Böhme-Nessler, a legal expert, put it this way. Böhme-Nessler basically said it was wrong for the GwG to invite judges to its own seminars and training. And who checks this? The research services of the German Parliament found in 2016. The requirement for judges to get further training is not written into law. For lawyers, it's required, checked by outside groups, and set by law. For judges, no rules. This isn't a new problem. Since 2008, the GwG has been openly criticized. The Bavarian Parliament looked into it many times. Panorama reported on it. ZDF Zoom reported on it. Süddeutsche Zeitung, FAZWDR, 2011, 2012, 2013, 2014, 2015. And in 2022, the GwG made a report for the Wetzlar District Court. In 2023, another one for the Offenbach District Court. In 2025, the GwG made a report for the Frankfurt Higher Regional Court. During this time, the GwG didn't shrink its network. It grew it. New locations, new partners, new experts, all over Germany. Source, GwG website as of 2025. During this time, no independent group was set up to check family law experts, no registration list, no outside quality control, no legal requirement for the judges who order these reports to get further training. We're not guessing about why this is happening. We're just noting what's been documented. Over 17 years of public criticism, questions from Parliament, national news reports. No real change in the system. The network grew. Family courts still order reports from them. Anyone who looks at these facts will draw their own conclusion. We're just pointing out systems that, for over 20 years, have shown no change despite documented criticism and have even grown, make you wonder what motivates them to change. Now let's talk about what all of this means. A family court report isn't just an academic paper. It decides where a child will grow up. If they'll see their dad, if they'll see their mom, how often, under what rules, if at all. And judges follow these reports, according to Joachim Lüblinghoff from the German Association of Judges, in 90% of cases. 90%. 10,000 family court reports each year in Germany. Each one is a huge change in a child's life, a parent's life, a family's life. Research shows what this causes. Balmer, Mathewson, and Haynes, 2018. They studied parents who were kept away from their children. Mental trauma. Being left out socially. The loss of all control over their own life. Jennifer Harmon, 2017, reported 23% of parents affected by parent-child separation reported trying to end their lives. And the children? Children who lose a parent, not to death, but because of a report, carry that with them their whole lives. A finding that was not used correctly. A diagnosis without a clear standard. A recommendation that goes beyond the facts collected. And a judge who follows the report. As in 90% of cases. Behind each of these numbers is a child. In one of the cases we looked at, the report suggested the child should live with the father. The court agreed with the report. A few years later, the child was placed in foster care. This isn't just a numbers problem. How much longer will children be treated like objects, to be divided, assigned, or placed? How much longer will professionals make money from this system, while children pay the price? Not in money, in years, in relationships that never happened, in a childhood that didn't have to be this way. This is about fairness. What is a diagnosis in a family psychological report? By scientific standards, a hypothesis, not a fact, not a judgment, not an argument. Let's start with the term that's central to all three reports, parental fitness. It's in the title, it's in the court's order, it's the basis of the recommendation. What does it mean? The Federal Constitutional Court has a clear stance on this. No one has to prove they are fit to parent. The opposite must be proven. Parents are fit to parent until a court legally decides otherwise. And science? A review in the Journal of Child and Adolescent Psychiatry and Psychotherapy, 2019, states, despite the central importance of the term, there's little agreement on its definition in psychological literature. In German-speaking countries, there's no procedure that explicitly claims to measure parental fitness, a term without a clear scientific definition, without an exactly measurable procedure, used as the basis for court decisions that shape the lives of children and families for years. That's the starting point. Let's see what's made of it. Three terms need to be scientifically clarified here. Autism spectrum disorder is not a mental illness. It's a neurological developmental disorder, present from birth, lifelong, neurologically based. This is stated in the S3 guideline and in the World Health Organization's ICD-11. A narcissistic personality accentuation is also not an illness. An accentuation describes personality traits within the normal range, without disease value, without an ICD code, without a clinical threshold. The Frankfurt report itself notes, there is no formal disorder. And neither a neurological developmental disorder nor a personality accentuation alone justifies limited parental fitness. Only the individual case is decisive. Let's see how the present reports deal with this principle. The Fernuniversität Hagen evaluated 116 reports for the state of North Rhine-Westphalia. The result: only a minority met professional quality standards. More than half had serious flaws. 3 other independent studies, TU Dresden, Leitner, Current Analyses, came to the same conclusion over 3 decades. In the report from Offenbach from 2023, it is noted that there were indications of an autism spectrum disorder, specifically Asperger's syndrome, in the father. A few lines later, the report states that, regardless of the actual diagnostic classification, the father showed significant abnormalities in social interaction that would affect his parenting skills. The report admitted the uncertainty, and yet it continued to argue as if the diagnosis was certain. That's not medicine, that's rhetoric. An expert report is a piece of evidence. It's given to a court. A judge reads it. And in 90% of cases, the judge follows what's written in it. This means the methods used to create an expert report are not just an internal matter for the experts. They are about the quality of the evidence. In science, there's a basic rule that comes from Karl Popper. A statement is only scientific if it can be proven wrong, if you actively try to disprove it. Someone who only looks for data that supports their idea isn't doing science. They're just confirming what they already thought. Let's compare. Someone who wants to prove the Earth is flat can gather observations that support this idea. They can ask witnesses. They can write down what they see. They can create a document that sounds convincing. As long as they pick methods that confirm their result, and don't use any that could prove it wrong, they will reach the conclusion they intended. This is exactly what the minimum standards for family psychology reports describe when they ask for standardized procedures, normal samples, methods that can be repeated, gold standard diagnoses, not because of paperwork, but because only then do you get a result that doesn't depend on who is doing the examination. That's the difference between a diagnosis and a guess. Let's look at what the reports themselves admit. The Offenbach report states that arguments were made regardless of the actual diagnostic classification. The Wetzlar report admits that it remains unclear whether the diagnosis was actually made or merely suspected. The Frankfurt report states that the findings suggested the problems were more situational and stress-related. 3 reports. 3 clear admissions of uncertainty, and in all 3 cases, still a clear conclusion, still a recommendation to the court. He wrote an opinion in a document, and the court treated it as evidence. There's one last question that comes from all of this. Germany signed the International Covenant on Civil and Political Rights in 1973. Article 7 says that no one can be forced to undergo medical or scientific experiments without their willing consent. Germany's highest court, the Federal Court of Justice, decided in 2010. An expert assessment in family law is voluntary. Parents cannot be forced. No disadvantages should come from refusing. This is the law. And what about real life? If you refuse the assessment, you risk losing custody of your child through an expert report based on existing documents, which uses your refusal against you. If you participate, you submit to a process that, as we've seen, in many ways doesn't meet the scientific standards it claims to. If a method doesn't meet the accepted gold standards, if it can't be repeated, isn't standardized, isn't proven to be accurate, then it's not a proper clinical procedure. Then it's an experiment. We're not making a claim, we're asking a question. When does an assessment that isn't scientifically sound, and whose results shape the lives of people and children, cross the line that Article 7 of the ICCPR intends to protect? And there's another part to this. The father in the Offenbach and Frankfurt reports has an officially recognized disability. That's not just a claim. It's a finding confirmed by authorities. Germany's basic law is clear. Article 3, Section 3, Sentence 2. No one shall be disadvantaged because of their disability. The UN Convention on the Rights of Persons with Disabilities, which Germany signed in 2009, is also clear. Article 23, Section 4. A parent's disability cannot be a reason to separate a child from their parents. Neither of the two reports mentions the disability. Neither checks if behaviors that were called pathological, like suspected Asperger's or narcissistic personality traits, might be linked to an already officially recognized disability. Instead, new diagnoses. Without a gold standard, without considering the existing finding. This brings up another question, this time not about the methods of the reports, but about the constitutional and international legal framework in which they were created. If a person with a recognized disability is labeled as having problems in a report, without their disability even being mentioned, is that a scientific assessment? Or is that discrimination because of a disability, which the basic law clearly forbids? The child was 2 years and 3 months old. The method the Offenbach report used to check attachment quality, the Heidelberg-Marschak interaction method, or HMIM for short, is, according to its own expert documents, only good for kids between 4 and 7 years old. This is stated in Franke and Schulte-Hölzel, 2019, the very book the report itself uses as a source. That's 21 months younger than the scientific minimum. Validation means the method has been scientifically checked and confirmed to be reliable for that age group. For younger children, this scientific basis is completely missing, yet the results from this method were still used to make a court decision. In the same report, a second flaw. The Offenbach report suggested the father might have an autism spectrum disorder, and for the child, it suggested early childhood autism. Based on what? Observing behavior during a conversation. What wasn't used, even though the report itself said it was needed, ADOS-2, ADIR, an intelligence test, a caregiver from childhood, a specialized expert center. The report stresses that a wrong diagnosis could have big effects on the person's future and outlook. It said it was super important to get an expert center to check things out. This warning is in the report. But the expert center wasn't brought in, yet the diagnosis was still used. Case 2. Wetzlar District Court. GwG 2022. The mother and the second child refused to take part in the assessment. The report documents its own methods in the summary. Literally, conversations with the first child and the father. Observation of interaction with the father. Home visit to the father. Information from third parties. The mother, not there. No conversation, no observation, no home visit. And yet, the report concludes on page 107 that there are extensive deficits regarding the mother's suitability for parenting. The mother was not even asked. There is exactly one psychological test in this report that concerns the mother. It was not done by the GwG expert, but by another expert. The result, no psychological problems. How does the report deal with this? It quotes the result and then states that the test scores should not be interpreted at all, or only with special caution. A result that clears the mother is questioned methodically. A result about her parenting ability, which is based solely on the father's and child's statements and file contents, is presented as certain. Based on this, the report recommends that the first child move in with the father. The second child, here too, a suspected autism diagnosis. And the report itself admits, it remains unclear to the expert whether the diagnosis was actually made or only suspected. Unclear, in the report. And yet, part of the basis for the recommendation, the minimum requirements for family law reports are clear. Interviews with everyone involved are a basic requirement for any assessment of parenting ability. Without exception. The third report, ordered by the Higher Regional Court in Frankfurt am Main, prepared by the GwG, the same organization. This report also comes down hard on the father. It says he has narcissistic personality traits, limited empathy, and isn't very willing to think about himself. It recommends only supervised visits, for at least a year. Sleepovers, not in sight. One finding is different from the Königstein reports. Regarding the father's VEI, the report quotes the Test Institute's evaluation as saying that a valid profile exists. The patient carefully and consistently answered the questions, was very open and honest in his statements, and did not give the impression of wanting to hide anything. Furthermore, the clinical scales were within the normal range. Normal range. That's the result of the only standardized test used on the father in the Darmstadt report. And the higher scores that the instrument also shows? The Test Institute, after its own evaluation, considers them not unusual for young adults, especially young men. In the findings section, the report explicitly states that these values suggest that the observed limitations are more situational and stress-related. Situational. Stress-related. The father has barely been allowed to see his child for years. The fact that he's stressed isn't a sickness. It's a reaction. Still, the report uses this result to say he has narcissistic personality traits. It recommends only supervised visits, for at least a year. Sleepovers, not in sight. The report itself recognizes that the findings are about situational stress. And yet, it still diagnoses a personality problem. No standardized method for narcissistic personality was used. No MCMI, no NEO-PIR, no narcissistic personality inventory. The only test psychological basis, a FAU-AEH result within the normal range. That's not diagnosis, that's interpretation, against its own findings. Upper Franconia. A family law case moves from Hof, Saale, to Bamberg. The starting point, a family psychological report from a GwG location. The Hof District Court relied on this report and rejected the father's request to remove the expert. From here, the case went to appeal. In family law, bias doesn't mean guilt or intention, but rather a good reason to believe there's a lack of fairness. Section 406 of the Code of Civil Procedure allows an expert to be rejected if trust in their impartiality is shaken. The standard here is what a reasonable person involved in the case would think. In 2020, the Bamberg Higher Regional Court overturned the decision. This case is from 2020. The child couldn't see their parents for months and was taken into care. The decision was further delayed due to the unique global COVID-19 situation at the time. In its reasoning, the court pointed out three connected issues. Frequent changes of lawyers were unfairly seen as a negative mark on parenting ability. The father's written statements were described as very long, but were actually only 4 to 8 pages. And the predicted costs for the child were just guesses and unfairly negative at the time of the assessment. Altogether, this showed a lack of a fair and understandable standard. Added to this was the expert's accusation that the father was significantly reducing his child's assets through how he handled the case. Also, his behavior was unfairly and randomly labeled as a mental health issue, without any scientific method. The result is that the case was sent back. Time passes, contact remains unclear. The child's well-being needs a fair and verifiable standard. For parents, this means rights and duties. It is possible to reject an expert under Section 406 of the Code of Civil Procedure. The reasons must be proven, specific parts of the file must be named, and unfair criteria must be clearly pointed out. This allows for judicial review. A report is evidence, not a judgment. It should be reviewed in court, and fairness should be in the report itself. This decision gives hope, but unfortunately, it's a rare exception. What was corrected here points to a bigger problem, a lack of quality control. In the next part, we'll check what minimum standards require and what's actually in the files. All three reports say they meet the basic rules for good expert reports in child custody cases. All three reports state that the report was prepared according to the minimum requirements for the quality of expert opinions in child custody law. And then they show ways of doing things that, based on our review, don't meet these requirements. The Frankfurt report isn't any better. It does use the GwG test, which is a standard way of doing things. But the result of this test is clear. It's within the normal range. And yet the report still says there's a personality problem, even after it noted that the findings were due to stress from the situation. Same pattern. Different diagnosis. Different place. Same structure. A conclusion that goes beyond the facts gathered. And the report itself gives proof that shows the opposite, but then it ignores that proof. In 2022, in a GwG report, the only test for the mother showed no problems. The report questioned it and still gave a bad judgment. In 2023, in a GwG report, the report says the gold standard is a must-have, but then it doesn't use it. In 2025, in a GwG report, the report talks about the VEI test and says the findings are due to stress from the situation. And yet, it still diagnoses a personality problem. 3 reports. 3 different times. Same pattern. The Hagen study showed what's written here, conclusions that go beyond the actual information gathered. 56% of family law reports don't have proper psychological theories. 85.5% don't explain why certain methods were used. This isn't just 1 or 2 cases. This is how the whole system works. Behind each of these careful points is a child. A child who isn't asked. Who doesn't understand why they can barely see their dad anymore. Who suffers the consequences without ever having a choice. The suspicion of Asperger's, never checked with a proper test. The suspicion of autism, not confirmed at the specialized center. The mother's parenting problems in the Wetzlar report, the basis for the diagnosis, a test with no findings, question methods, and not a single direct meeting with the mother. Between the first report and its correction, years. Years when a relationship couldn't grow. This is the human side of documented mistakes in methods. This is what's at stake. For over 17 years, criticism, reports, requests, no registration system, no oversight, no big changes, and 3 more expert opinions from 2022, 2023, and 2025. The well-being of children is not something we can compromise on. It's not a market, not a business model. HMIM used at 2 years and 3 months. Only proven to be accurate from 4 years old. Asperger's diagnosis without ADOS2, without ADIR, without an intelligence test, without a specialist. Parenting ability judged, without even 1 direct meeting. Result of a test that showed no problems, questioned in its methods. Autism diagnosis of a child. According to the report itself, it's unclear if it was actually made. Still, it was used to recommend something to the court. Both diagnoses, later not confirmed. Same organization, different locations, different methods, different results. These aren't just different ways of looking at things. These are proven, recorded mistakes in how things were done. You can read about them in the reports themselves. Talk about it. Share this video. Because if you stay silent, you protect the system, not the children.